Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Evidence Act, we were discussing chapter 2, which is all about relevancy of facts covered between section 5 to 55. In this series, we were discussing certain provisions related to opinions covered between section 45 to 51. Out of these 7 provisions, we have already discussed section 45 and 46, which are focusing about expert opinions. Here comes section 47 and the amendment section, that is 47A, which is discussing about opinion as to handwriting when relevant. Now this is going to be interesting. Why? Because we have already discussed something about handwriting when we were discussing section 45. Why are we discussing it again? Now that's the interesting part. I will explain you section 47, 47A, illustrations, case law, and finally the difference between section 45 and 47. With that, I am taking you to the first slide. Section 47 discusses about opinion as to handwriting when relevant. The Bare Act provision says when the court has to form an opinion as to the person by whom any document was written or signed, the opinion of any person acquainted with the handwriting of the person by whom it is supposed to be written or signed, that it was or was not written or signed by that person, is a relevant fact. Let us try understand this provision with the help of below chart. Before getting into the chart, I would like to give a scenario. Imagine there is a document available with a particular court, and the question in front of the court is whether such document is written or signed by Mr. X or not. That is the question. Now coming to the chart, the court now has to form an opinion related to that particular document which is available with the court. And what is that court has to make an opinion? Whether such document is written or signed by Mr. X or not. That is all court has to form an opinion. That is the issue we are having now. But how will court decide now? Court cannot decide by itself because court don't know whether such document is written or signed by Mr. X or not. The court doesn't know. Now the court will take somebody's help. Now if any person comes to the court and confirms that whether such returned or signed document is of Mr. X handwriting, in that case the opinion made by any such person is relevant. And the important point we need to observe here is such any person who is coming to the court should be familiar with X's handwriting. That is very, very important. He need to be familiar. Only on the basis of such familiarity, he confirms to the court whether such document is written or signed by Mr. X or not. Now, if we remember section 45, there also we discussed about handwriting, but there opinion was given by experts. But here it is given by any person, but the only very important or key information that we need to remember is such any person should be familiar with that particular handwriting. In this case, if it is the handwriting of Mr. X, then such any person who is confirming that the document is written or signed by Mr. X should be familiar with X's handwriting. That is all we need to understand from section 47. Here in this section, the term acquainted is very, very important. Acquainted means getting familiar with. Now for that there is an explanation available which reads, a person is said to be acquainted with the handwriting of another person in 3 different scenarios. The first one being when he has seen that person write. Now in the above case, if the person who is confirming, if he has seen X writing or signing such document, that becomes getting familiarity. Or when he has received document purporting or claiming to be written by that person in answer to documents written by himself or under his authority and addressed to that person. Now, for example, such any person has wrote something to Mr. X, and in reply he has got letter from Mr. X, and there he has already seen X's handwriting and became familiar. That is the second scenario. Or in the ordinary course of business, now repeatedly there were letter transaction between the person who is confirming and Mr. X, and in the ordinary course of business the person who is confirming has seen X's handwriting many times and he has become familiar. In all these cases he is quite habitual with the handwriting of Mr. X, and he can confirm whether such handwriting is of Mr. X or not. That is what given under explanation, and with that I am taking you guys to the illustration etc. in my next slide. The illustration goes this way, where there is a question in front of the court whether a particular document is having A's handwriting or not. Now A is a merchant who lives in London, and the question here is the document available with the court whether it has the handwriting of A or not. The same need to be confirmed. Now there are three people, that is B, C and D, who are connected with the handwriting of Mr. A. B is connected because he is a merchant and he was in touch with Mr. A on ordinary course of business, where he has wrote many letters to Mr. A and has got reply. Now when he gets reply, he has seen the handwriting of Mr. A several times and B can confirm. Likewise, C is the clerk of Mr. B who is filing all the documents received by B. So he is quite familiar with A's handwriting because he has also seen it many times. And finally, D is B's broker, so he is also got lot of communication via this office and he has also seen lot of letters by Mr. A. That way he is also familiar with the handwriting of Mr. A. Here the opinion made by B, C and D will become relevant because they all are acquainted or familiar with the handwriting of Mr. A. That's all about the illustration. The case law that you can refer for this particular section is Shankarappa versus Shushila Bai, where the question in front of the court whether two people are married to each other or not, and the wife here says that there was a letter from her husband to her brother where he has confirmed that I am his wife, and she recognized the handwriting, or she said I am familiar with the handwriting of my husband and this letter has the handwriting of my husband. That way this is an evidence that me and that person is wife and husband. That is what discussed in this particular case law. And finally, before moving to the amendment section and the difference between section 45 and 47, we need to remember that we need to read this particular section along with section 67 and 67A of chapter 5, which are discussing about documentary evidence. So these two sections are discussing about proof of signature and handwriting of person alleged to have signed or written document produced, and proof as to electronic signature. Now here there will be a lot of aspects we are going to discuss, like the person who has seen them writing or who is familiar with them writing. All of that will come to picture, that I am discussing when I discuss about section 67 and 67A. For now, let's move on to the amendment section. 47A, which is an amendment section, discusses about opinion as to digital signature where relevant. It says when the court has to form an opinion as to the digital signature of any person, the opinion of the certifying authority which has issued the digital signature certificate is a relevant fact. Here the question is on digital signature, and if the certifying authority which has issued the digital signature certificate, in that case the same becomes relevant fact. Moving to the last part, let us try understand the difference between section 45U and section 47. I am limiting it to the extent of handwriting, which is being seen as an expert opinion under section 45U versus section 47. Now, there the relevancy of section 45U is applicable only to the expert opinion. If an opinion on handwriting is made by an expert, then it becomes relevant under section 45U. Whereas under section 47, it can be by any person who is familiar with such handwriting. So the relevancy is different in both the cases. Under section 45U, it is relevant only when it is made by an expert, whereas under section 47, it can be anyone who is familiar with the handwriting. That is the first difference. The second one, I have already used this term familiar. The one who has acquainted or is familiar or conversant with the handwriting of the person in question. In the case of section 45U, there is nothing like that. The expert will have two documents. He compares, and the basis of his knowledge, experience, observation, he makes an opinion, and that is an expert opinion. Whereas under section 47, there is familiarity available. The person who is making the opinion has seen the person who was writing, or he has got those transactions via some business course, etc., and only with such familiarity he is making the opinion. He is not an expert. He is making his opinion because he is familiar with the handwriting. That is the second difference. The third difference, in whose present this document is made. Under section 45U, when the document is made, the person who is making opinion will definitely not be there. He is called by the court to see the document and make the opinion. So he was never in front of the person who has made the document, who has written or signed the document. He came to court and then he is seeing the document and he is making comparison and he gives his opinion. Whereas under section 47, there is all chances that such document is made in presence of them only. That means the person who is making the opinion only, or may not be. It need not be that every time he need to be in front of those person who is writing. Like the previous slide when I was explaining, I told you very clearly, in the course of business where there is a lot of letter transaction, he has received a lot of letter as reply and he has seen the handwriting. That is how he became familiar. That is also sufficient to make an opinion, but he can be in front of the person who is writing it also. There are possibilities on that also. So it can be maybe or may not be, but in the case of section 45U, it is never done in front of the expert. That is all we need to understand as far as the difference between section 45U and 47 are concerned.
What? How is a tree in water? I thought trees were supposed to be on land. I'm not understanding this. This is confusing. This is crazy.
Nishan, what's happening there?
Nothing, Papa. Coming there to finish my homework. With that, I'm concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye-bye.